I'm attorney Phil Giacino, and this is WLINY's Finding Common Ground here on Altice. If you miss any of my shows, you can catch them on YouTube by going to WLINY Internet Radio. When you think of WLINY, think of Long Island, New York, the world. I also do a show that I bill as Politics, Law, and Social Commentary with an Edge. You can see that on Fridays at 8 p.m. on WLINY, either YouTube or Facebook. Now, I often have guests on my show. Tonight I'm flying solo. And there is one thing I want you to know about this show. I say what's on my mind. I say what I think. To quote the great Charles Krauthammer, you betray your entire life when you don't say what you think. Now, on this show, we say what we think. This show is devoted mostly to the law. I'm a practicing attorney. Been practicing for about 30 years. I'm a former prosecutor, criminal defense attorney. I'm in court every day handling custody cases, child support, equitable distribution, divorce, family court. So I bring experience to the table. And most of this show will be about that. Tonight, the show is going to be about child custody. We're going to cover parenting time, which used to be called visitation. We're going to talk about relocation. We're going to talk about orders of protection and how current technology impacts on family court issues. And you'll see what I mean. That's going to be a lot of fun. To give you a little bit of background about myself, as I said a little while ago, I'm an attorney here in Lake Grove, New York. I've been practicing for about 30 years. I may not look that old, but that's how long I've been practicing. I was an assistant district attorney in Suffolk County many moons ago, and I was in the domestic violence unit where we handled orders of protection, and also in the district court bureau. The first topic I want to get to is what they call child custody and parenting time. Now, in Suffolk County, there are two courts that handle child custody. One court is Supreme Court, where they handle divorces. That's called the matrimonial part. Supreme Court also has a part that handles car accidents and things like that. But they also have a matrimonial part that handles divorces and all the issues that go along with it. The other court where you can get custody and or parenting time is family court. Now in Suffolk County, or any county for that matter in New York, you cannot get a divorce in family court. Let me repeat that. You cannot get a divorce in family court. You have to go to Supreme Court. Now, if you are married or not married and you want custody or parenting time, you can go to family court. So I want to make that distinction. Family court can't give you a divorce, but it can handle many issues. They cover child custody. They cover parenting time. They cover neglect cases. They cover child support. They cover adoptions. Those things are handled in family court. Now, what happens when you want custody of your child? First, you should see a good attorney. And that attorney will advise you as to what your rights are. Now, for instance, if you go to court and you can't settle on a custody arrangement, the court will in all likelihood appoint what they used to call a law guardian, which is now called an attorney for the child. That attorney is not a psychiatrist, is not a psychologist. Their role is to represent the interest of the child or children. It could be one child, two child. As long as their interests are relatively close, you can have one attorney representing more than one child. Sometimes you have to have more than one law guardian if their interests are not the same. For instance, if you have a 15-year-old child and a 17-year-old child, one says, I want to live with mom, one says, I want to live with dad. In all likelihood, the court will appoint two law guardians or two attorneys for the child. I often go back to that law guardian because I was one myself for 5 years, many years ago, but they call it attorney for the child. Now, where does that attorney come from? That attorney is appointed by the court. Some courts don't even ask the attorneys if they want to have a say to some extent. They'll say, this is the attorney, and unless there's a conflict of interest, that's who it is. Some judges or referees might say, I'm going to suggest this particular attorney. What do you guys think? And sometimes the attorneys say, you know what? I'd rather have a different one. And that's fine. Ultimately, it's the judge or referee that determines who the law guardian will be. Who pays for the attorney for the child? In Supreme Court, it is the parties. There's a few exceptions. If the parties are poor, they can pick one at, let's say, panel rates, where they have a panel they can pick from. But usually it's a pro rata basis. So if the husband makes $100,000 and the wife makes 50, then the husband will probably pay 2/3 to the wife's 1/3. In family court, for the most part, the parties do not pay for the attorney for the child. There's a panel that's appointed. Generally, the judge, they take turns. So you might have a particular law guardian who's getting cases from certain parts or certain floors on a particular day, and the judge really doesn't have much say. Say, okay, it's Joe Smith, and that's who they pick. Now, what is the role of the attorney for the child? Very simply, to represent the interest of that particular child or children. Now, in, let's say, a divorce case, I represent, let's say, the mom. Another attorney represents the father. My job, and I know it sounds a little callous, my job is not to look out for the interest of the child. I don't want to do anything to hurt the child, but my role is to look out for my client. In the example I gave, it was the mom. That's my job. The attorney for the father, his role or her role is to look out for the rights of that particular client. The child's rights can fall through the cracks if there's no one looking out for that particular child or children. The judge is not tasked at that role until generally later when there's a trial and the judge gets to talk to the child or children. But in the beginning, the judge is not going to come out and say, all right, little Johnny, come back here, let's have a chat and see what you want. It doesn't work that way. So they appoint an attorney. They can even appoint an attorney if the child is an infant. Let's say the child is 2 months old, and it happens all the time. That child doesn't speak yet. So you might say, well, what is the attorney for the child going to do? He or she can't speak to the child, but they can speak to the mother, they can speak to the father, they can maybe go to the house. They can make a recommendation based on the facts and circumstances as they see it. It's another set of eyes and ears for the judge to rely on. Because don't forget, when I make my argument, the judge knows it's representing a particular party, same as another attorney. When the attorney for the child speaks, they generally get listened to a little bit more because they are looking out for the child. Right? We're all equal. The law guardian or the attorney for the child doesn't have any more power than I do. But in certain cases where they get to speak to the child, they really have their finger on the pulse of what might be in that child's best interest. Well, I might not know that. The child might tell the attorney for the child something I will never know unless the case goes to trial. Because the attorney for the child is not allowed to divulge what the child said verbatim. Obviously, you're going to get a sense of what's going on. If the law guardian or the attorney for the child says, I recommend that the child go with dad, or I recommend the child go with mom, we might not know what was said behind closed doors, but we have a pretty good idea. What is the role of the attorney for the child at trial? Now remember, they appoint the attorney will make a recommendation, and they try to help settle the case. And often that helps, because the child might say, look, it's a 12-year-old kid, I spoke to the child, he wants to live with mom, or he wants to live with dad. And we get that. And I tell my client, if it's good for him, I say, great. If it's not good for him, if I represent the father and the 12-year-old child clearly wants to live with mom, I'm going to say to my client, we can still go to trial. The attorney for the child makes a recommendation. They don't call the shots. The judge can, and we'll get to this later, the judge can say, thank you, attorney for the child, for your recommendation, but I'm going to go a different way. And that happens often. So at trial, what is their role? They question the witnesses just like I do, and just like the attorney does, other attorney. So for instance, let's say it's a divorce case, and I represent the wife, and she is the plaintiff. We go first. I call my client. I ask a question, she testifies. It's called direct examination. When I'm done, the other attorney questions her. It's called cross-examination. Then the attorney for the child goes. So the witness gets questioned by 3 people. Attorney for the father, attorney for the mother, and the attorney for the child or children. And then I get a chance to question my client again. It's called redirect. But their role is to ask questions. And often they ask very good questions because they had the opportunity to speak to the child, something I don't get to do, nor does the other attorney. So sometimes, I remember one case where I'm sitting, it was a small room, and I'm sitting near the other attorney, and the attorney for the child starts questioning, I believe it was the mother, and asks her questions about things that I didn't have any clue about, nor did the other attorney. In fact, we looked at each other like, where's she going with this? But it became apparent later, and we've later found out the attorney for the child didn't want to tell the attorneys about this issue because she wanted it to be, in a sense, a surprise, or in a situation where the other person couldn't really plan ahead and come up with a pat answer. What is the role of the attorney for the child after the trial? So the trial is over. The judge has not made a decision yet. What happens next? If the child is old enough to communicate, they bring the child in the back. It's called an in-camera interview in the chambers of the judge. Sometimes it can be in the courtroom, but it's outside my presence, it's outside the other attorney's presence, and outside the presence of the parties. The only ones that will be in that room would be the judge, the attorney for the child, the child or children, a court reporter, and a court officer. Now, we, the attorneys, get to submit questions to the attorney for the child to take back into that room. They don't have to ask any of them. They could ask all of them. They could ask some of them. That's up to them. So we ask questions like, I might say, ask the child what happened, Thanksgiving 2017. The law guardian, attorney for the child, can ask the child that question, but doesn't have to. So after the in-camera interview, the attorney for the child makes a recommendation. Now, usually the recommendation is made before that, but they can make another recommendation and say, based on everything, the child should be with this parent or that parent. Again, a recommendation, not binding on the judge, although it does carry a lot of weight. Now, what other resources does the judge have to come up with a decision ultimately as to what parent should have custody, and the parent that doesn't get custody, what kind of parenting time should that child have? These are the resources, in addition, of course, to the attorney for the child. One is forensics, where a psychiatrist or a psychologist talks to the parties, talks to the child, and comes up with a report. And the report can be very lengthy. And the report could say, mom suffers from this, or dad suffers from this, or mom is controlling and dad is uncooperative. They also talk to the child. They make a recommendation. Forensics tend to be expensive. You could be looking at $5, $10 grand potentially. We don't do that nilly-willy. We do that when we need to do that, and usually because there's a reason. Maybe one of the parties has a mental health issue, or there's an allegation of a mental health issue. We use forensics sparingly because it gets expensive, especially in a divorce. In family court, sometimes it might not be that expensive. It might be paid by the county. But in a divorce, generally, the parties have to pay for that in some portion or proportion. What they call pro rata. I used the example before. Husband makes 100, wife makes 50, 2/3, 1/3. The other thing that they can do, which you see a lot in family court, is what they call a 1034, just a statute, 1034. They check on who's in the household, the parties. Is there a boyfriend living there? Is there a girlfriend living there? Mom, dad, uncle. They look into that, and it's done by the Department of Social Services, and they come back with a report. Usually not a very long report. And also, if any of the parties have been arrested before, have any of the parties had CPS on them, and was it indicated, or unfounded? Again, another resource for the judge who might not know exactly at that moment which way to go, might find out, oh, dad has had 3 felony conviction and mom is squeaky clean. That could tilt the balance. A home study. A home study is similar to a 1034, except it's more about the home. Mom's home is this, dad's home is this. Again, another piece of information. None of the things that I talk about tonight, for the most part, is 100% controlling. In a little while, we're going to get to the factors, what a judge considers in a custody case, all included in the best interest analysis. But nothing, not one thing is controlling. It's cumulative. What else can the judge rely on? What they call the in-camera interview. I talked about that a little while ago, where he actually gets to hear from the child or children. You could have a court-appointed psychologist in Suffolk County where somebody very good, her name is Jean Marie Massetti. Her job, she's hired by the court system, her job is to bring parties together and see if she can reach a settlement. What she likes to do is get the attorneys out of the picture, so she might say, take a walk, fellas or lady, and I'm going to talk to the parties. And she tries to reach some common ground, to steal the title of the show, common ground. If she can't, she's not supposed to go back to the judge and say, oh, that guy was a jerk, or that woman was a real pain in the butt. But she tries to bring about some kind of common ground. Sometimes it's on a temporary basis, sometimes it can be a permanent settlement that the attorneys can incorporate into the overall settlement. And that's free. Now, what are the factors that a court considers in determining custody? And there are quite a few of them. I'm going to go through them. One, of course, is the stability of the parents. If one parent is not stable and one parent is, then it would appear that the stable parent would probably get custody. There could be exceptions, but for the most part, stability is an important characteristic that a parent should have. Who has been the primary caregiver? That's also very important. If you have parties that have been married for 10 years and the father's worked 90 hours a week and the mother's always been there for the child, that could be a great guy, great provider, great dad. Mom's going to have the advantage in that analysis. Just like if the father was Mr. Mom and he stayed home, he would have the advantage with respect to that analysis. Child care arrangements. Maybe not as important as the first two, but let's say one party lives with their parents and they have a child care provider or providers built in. That's a factor. Drugs and alcohol. It's hard to be the custodial parent if you're a fall down drunk, or if you're on cocaine, or taking cocaine, or doing a drug that affects your ability to be a good parent. A factor. Mental health. If one of the parties has dementia, let's say, or a serious mental issue, that may disqualify that parent. Because let's say the parent has dementia. If she can't take care of herself or himself, how is he or she going to take care of a child? Physical health. That's a factor. Again, some of these are less, but it's important. Let's say you have a parent that's a quadriplegic. It's going to be hard for them to be the custodial parent of, let's say, a 1-year-old. It doesn't mean they're not otherwise a great parent, but that's a factor the court has to consider. One of the most important issues, can the custodial parent, the one that ultimately would have custody, foster a good relationship between the non-custodial parent and the child or children? Very, very important. That is one of the most important factors, because the judge wants to be sure, if I give custody to dad, and let's, for example, the father, but the father's going to say, I'm not going to cooperate, I'm not going to follow any order, mom's a louse, and I'm going to do everything I can to make sure she doesn't see this child. That father may have just disqualified himself from getting custody, even if he was the better parent for other reasons. Now let's just go back, I missed one. Abuse, neglect, abandonment. Obviously, if one parent neglects or abuses the kid, that's going to be detrimental and hurt that party's ability to say, I want to be the custodial parent. Abandonment. Obviously, if you abandon your child and then you come back years later and say, I want to be the custodial parent. Probably not. But in that is also parental alienation. which should play a bigger role, but doesn't always. Parental alienation, what is that? If one parent, it could be the custodial parent, usually the custodial parent, could be the non-custodial parent, makes it so that the other parent becomes alienated from the child. That is very bad, obviously. And that is something that can disqualify a party from having custody. Now, I'm going to put my 2 cents in. I've seen cases, not too many, but I've seen cases where parental alienation turns out to cause one party that had custody to lose custody. In the last year, I had a case just like that. I wish judges would be more, I don't want to use that vernacular word I was about to use, but be more gutsy with regard to this issue. Because if you're a father or a mother and the other parent is doing everything in their power to prevent you from having a relationship with your child, that person should be punished and should not have the ability to do so. How do you take that ability away from them? If they're the custodial parent, you strip them of custody. Now, I understand why judges don't want to do that. Because in a sense, what you're doing is this. I'll give you an example. Let's say you have a 10-year-old child. Mom has custody. Dad sees the child on alternate weekends and a day or two during the week. And, of course, holidays, summertime. And mom is doing everything that she can do to prevent dad from having a relationship. Oh, you can't see him tonight. Or telling the child, dad's not paying child support. Or dad cheated on me. Or dad's doing this. Or dad's doing that. Where the kid is going to say, you know what? I don't want to see dad. Because why? Because of what mom is saying to the child. Parental alienation. What does a judge do? A judge, a lot of times, will get fed up at some point and say, what do you want me to do? Do you take that 10-year-old away from the mother that he loves and cherishes, and who otherwise, and I'm not making excuses for the parental alienation, but otherwise takes good care of that child, doesn't abuse the child, she doesn't neglect the child, she feeds the child, she's there for the PTA meetings, she takes the kids to activity, the child to activities. Do you then say, I'm going to make an example of this case, and I'm going to take little Johnny away from his mom and put him with dad? That kid might have to go kicking and screaming. So I understand dad's position obviously is, I want to see my child. And if that's what it takes, do it. I could understand the judge and even the attorney for the child, because the attorney for the child is duty bound to be a mouthpiece for that child unless the child's very young. So if you have a 10-year-old, the law guardian could say, mom's doing a real bad job with respect to fostering a good relationship, but I don't want to say, take my 10-year-old client from mom. I'm going to make a suggestion. What could happen is this. The first time it happens, the judge says, ma'am, you better stop it. Because the next time we come back, I might take that child and give it to dad for a while to teach you a lesson. Or attorney's fees. So if you say to the mother, because dad had to file this petition, you're going to pay his attorney's fees. Now maybe she has the money, maybe she doesn't. Hit her with a judgment. Make it uncomfortable for that parent that's alienating another parent, with respect to the child, uncomfortable. Make it so that they don't want to do that. Punish them. Now, I said a little while ago, at some point the court makes a decision. Who's going to win, and I don't want to necessarily say who wins and who loses, but who's going to get custody and who's not. Now, often when cases settle, it's called joint custody. You've all heard that term, joint custody. Now, what does joint custody mean? Joint custody is not shared parenting. Shared parenting is a situation where it's kind of a 50-50. They split the week, or they do something where each party has the child or children about half the time. Joint custody is not necessarily that. And I always use the example of this. If I said to a father, let's say you're the dad, and I say to you, I'm going to give you joint custody, okay? And you're going to see the child 3 times a week. Or I'm going to give the mom sole custody, and you see your kid 5 times a week. Now think about that. He's going to say, well, I don't care what you call it. I want to see my kid as much as possible. So give her sole custody, give me 5 days, rather than joint custody with 3 days. I use that to illustrate. The point is, titles don't always matter as much as you may think they do. Right? Because people say, I want joint custody, I have more say. Who has the most say is generally this: the parent that has at least residential custody. If they have sole custody, obviously they have the final say. You're not going to have a vote every time. And even if you do, it's a tie. How do you break the tie? A judge will say, where does the child reside most of the time? Mom has residential custody, she has the final say. Dad has residential custody, he has the final say. But again, shared parenting is different. In shared parenting, it's more equal, as opposed to joint, which is not necessarily equal. So, but what do you do if you don't like the decision of the court? You can appeal. In New York, you'd appeal to the second department in Brooklyn. Now, if it's a child support issue, you would file an objection and then do an appeal once a judge renders a decision. Now, let me give you an example of a custody trial that I was involved in, where the law guardian, or the attorney for the child, recommended one thing against my client's interest, but yet the judge did something different and gave my client custody. It was a situation, and obviously I don't divulge names or anything like that, and I won't even in this case divulge ages. But needless to say, one of the parties' oldest child, or in this case the middle child, but it was the only real child involved, called the oldest child. There was an older child, but it wasn't really part of the equation, because once your child is 17, 18, and so on, not even part of the equation anymore. Certainly 18 and older. And then there was a younger child. The law guardian felt that my client's apartment wasn't big enough. And my client said, if I win, I'll get a bigger apartment. But right now, it's big enough for parenting time, and if I lose, I don't want to have to spend more money, and then I might be stuck with a year lease. So we had a trial, 3-4 day trial, whatever it was. And at the end of the trial, the attorney for the child said, Mom's apartment isn't big enough. And I remember the judge chiming in before I even had a chance to say anything. And the judge said, I don't care if these kids have to sleep on the floor. They can't continue to fail. Now, at the time, one of the children was doing very poorly in school. It was an issue. And this judge was stressing education and saying, look, we can't all have a 5-bedroom mansion. Sometimes we have a 1-bedroom. Sometimes we have a colonial. Sometimes we have a split ranch. All different kinds of houses, all different kinds of salaries and incomes. So it's not always fair to say who has the better house. It's never fair to say that. Who has the better house wins. Right? Again, it's a factor. If someone can't afford to put a roof over their head, they're going to have a disadvantage. Especially if it's not a divorce where maintenance is not involved. I'm getting a little off topic. But if the parties are not married, you can get child support. You can't get maintenance. So if the woman gets child support and still can't put a roof over her head and the child's head, dad might have an advantage. Because he's not obligated, if they're not married, to pay spousal maintenance. So in my example, the judge went against what the attorney for the child, in this case 2 children, recommended, and gave my client custody after the trial. And it was a success story. Both kids went on to do well in school. Give you another example where the case didn't go the way I wanted at first, but the old expression, if at first you don't succeed, try again. Went to trial, and to my surprise, the judge ruled against my client. Gave 2 little kids to the father who had a felony, and right around Christmas time, my client was devastated. And we would have had to turn the kids over, she would have had to turn the kids over, I think it was a couple of days before Christmas Eve. She hired me to do the appeal. I got a stay Now, a stay means that the court says, or the appellate court says, we're not gonna let that order take effect just yet. That's really what it is. So mom still keeps the kids, doesn't mean dad can't get them at a later date, but right now, until the appellate court looks at this, we're gonna keep things the way they are. And they did that motion. But the motion had to be completed. Now, I was going on a hockey tournament with my daughter, who was playing ice hockey at the time, and I was gonna be away right after Christmas until right around New Year's. So with my staff, including my dad, who's a paralegal, and my sister, who was an attorney for my firm at the time, and we didn't even have the technology we have today. This is many, many years ago. So I was using the fax machine at the hotel. I don't think I even had like a phone with email on it yet. And we won, not only won the stay, right, but we won the case. The court didn't even bother sending it back for another trial, ruled that the children belong with the mother, and basically said, and I'm paraphrasing now, that the judge's decision, a family court judge, I will not give his name, but that his decision was not based on sound logic or reasoning. My client got to keep her 2 kids, which was the right decision in the first place, but it took an appellate court to rule on that. Now, another factor, which can be an issue in and of itself or tied into custody, is what they call relocation. So let's say a couple is divorced. Let's use that example. They've been divorced for a number of years, and mom can't afford to live here. She's not making enough money. The rent is too damn high. She's not getting enough child support. What can she do? She can relocate. Now, some agreements say you can't unless you get a court order. Others are silent on it, so she could say, I'm going, and the husband or the ex would have to then file a petition or a motion keeping her here. But relocation, we're going to discuss relocation now. The leading case with relocation is called Tropia v. Tropia. And that sets forth the considerations that the court must follow. And again, not one more than the other, but we'll come up with something that the court thinks is fair, and either will say you can move or you can't move. One of them is the relationship between each parent. Give an example. Let's say mom wants to move to South Carolina because her parents live there. She can't afford to live here. I had a case similar to that where I won, where she got to go to South Carolina to live with her father. Now let's say dad is an absentee dad, and he's a deadbeat dad. Never there, doesn't pay any money. There's an excellent chance mom will be allowed to go, because you look at the relationship between each parent, each child and parent. So the father, in the example I just gave, doesn't have a close relationship with the child, never sees the child. Compare that to a situation where dad is father of the year. He's there at every activity, pays plenty of child support, buys the kids sneakers, does everything a great dad is supposed to do. Her chances would be less to be allowed to move. Doesn't mean she won't be allowed, but it's less. You also look at the context between the child and other family members. So let's say, the first example, dad's a deadbeat dad, there are no grandparents in the picture, no aunts and uncles. Again, more likely to be allowed to go. Let's say if a great dad, his mom's here, his dad here is here, grandparents of the child. The court looks at that and says, wait a minute, if this woman is allowed to go, dad is not going to see the child as often, grandma is not going to, grandpa, there are 10 cousins that the child is not going to get to see. Again, a factor. Another factor is the reason for the move. If a woman says, well, I met this nice guy on Facebook and I want to be allowed to move, probably not. If she says, I like the warmer weather than this New England winter, probably not. If it's, I can't afford to live here, they're foreclosing on my house, I'm not getting much in the way of child support, I'm only making $30,000 a year, I have family in Florida, they can put me up, I can get a job, more likely to be allowed to go. The impact of the move on the child. And again, it's not an exact science, but the attorney for the child will speak to the kid. Let's say the kid is saying, I'm gonna miss my dad tremendously, I don't wanna go, and is broken up about it, or maybe even has issues that go beyond just not wanting to go. They look at the impact of the move. Will it make things better for the child? Maybe the child's in a studio with the mom struggling. They get to go to North Carolina and they're gonna have a better life. The court looks at that. Now, what does the parent that wants to make the move have to show the court? They have to show that they can make an accommodation. Very simply. So if they say, I'm gonna move to Florida, but most of the summer, the child's gonna come back to New York and stay with dad. He's gonna get most of Christmas. That February week, he's gonna get most of February. Summertime, all these other things. Sometimes there are a lot of Monday holidays. We just had one. Maybe the child can come up and be with the dad Friday, afternoon, let's say, Saturday, Sunday, no school on Monday. That might be the ideal way to do it. So they have to show an accommodation. If they can show an accommodation, the court might be more likely to allow that parent to move, with the other factors being considered. But it's very important. The takeaway from the relocation issue is, it is mostly for financial reasons. Right? The example I used where I met a guy on dating service and he happens to live in North Carolina. No, that's not good enough. If a custodial parent makes very little money on Long Island and has greener pastures to go to another location, that will usually help that parent. And what I do when I'm trying these kinds of cases, and I've had a lot of success with it, is you say, all right, what kind of school system is a kid gonna go to? Let's say the child lives here, and I don't wanna insult any school districts, but let's say it's not a very good school district. And the child gets to move to some other location, and it's a really good school. That's a factor. Court can say, the impact on this kid is gonna be a good impact, not a negative impact. Now let me just jump to child support for a second, because I want to talk about the interplay. People often ask me, well, if my spouse or the father of the child is not paying child support, do I have to let him or her see the child? The answer is yes, generally speaking. Now some judges might hold it against a party, but for the most part, two separate issues. Right? You can have a father that doesn't have a you-know-what to you-know-what in, but he's a great dad. Or you could have a dad that has all the money in the world and is a really bad parent. Should he be allowed to see the child because he can pay all kinds of child support? No. Separate issues. Okay? Now, what happens in an extreme case where someone doesn't pay child support? They can be punished. They could go to jail. They could lose their driver's license. If they're an electrician, they could lose their electrician's license. If they are a lawyer, they could lose their license to practice law. When I certify, every 2 years, we attorneys have to certify, we have to put down about our child support situation, if we have it. And if someone is behind, it could affect their ability to practice law. So very important that people, man, woman, doesn't matter, pay your child support. And if you can't afford to do it, file for what they call a downward modification. I handle those all the time. Sometimes they work, sometimes they don't. It depends on why the person is making less money. And so if for some valid reason you can't meet your child support obligation, file that downward. On the other hand, if a parent is having a tough time making ends meet, maybe didn't get an adjustment in the child support for a number of years, can come back. We're going to talk about child support on another show, but there are certain conditions that allow you to come back into the court. Right? And I'll save that for another day. A really important topic I want to talk about is orders of protection. Now, when I started out as a young assistant district attorney, I was put into a newly formed domestic violence unit. This was about 1990. Right? And some women were killed, so they wanted to create this bureau to make sure cases didn't fall through the cracks. And eventually, it's morphed into 2 domestic violence courts. See, back then, we had a domestic violence unit, and the cases were scattered throughout the district court, for the most part. Now they have 2 domestic violence parts here in Suffolk County, where Judge Walutis is in one, and we have another judge, Judge McDonough, two very good judges, in the other part, where cases in there are strictly domestic violence cases. Now, what is a domestic violence case? Obviously, between spouses, between a boyfriend and a girlfriend, let's say they have a child in common, between mother and son, father-son, father-daughter, all different kinds of things, as opposed to two neighbors going at it. They wouldn't be found in the domestic violence part. Now let's go to orders of protection. Generally speaking, there are two types of orders of protection. One is what they call a stay away. If you get served a stay away order of protection, you can't go near that person. You can't, and if it's specified, you can't call the person. You can't even have a friend say, hey, Bill, can you contact Sally? I really need to talk to her. It's against the law. You're in violation of the order of protection. Third-party contact, they call it. Then you have what they call a refrain from order of protection. Refrain from order of protection allows you to be near that person, but you can't harass them, stalk them, menace them. You see that, and let's say a husband and wife live together, and the wife gets an order of protection. But what the husband did isn't that severe. So the judge doesn't want to kick him out of his own home. He can give her a refrain from order of protection that makes it so that he can live there, he can talk to her, he can call her. He can't harass her. If he comes home one day and says, you know what, I'm going to kill you, or pushes her, or anything like that, she calls the police, they arrest him. He's looking at a potential felony, criminal contempt in the second degree. Now, where do you get orders of protection? Basically, two courts. Right? You can get them in Supreme, but for the most part, you get them in criminal courts, and you get them in family court. Supreme Court judges usually leave the orders of protection to those courts. I've seen cases where the judge might say, yeah, bring it in. There's an order of protection case, bring it in. We also have the integrated part, which is Krecker here in Suffolk County, that can handle the criminals, like one-stop shopping, criminal, family court, the divorce, orders of protection. But let's focus in on the family court and the criminal court. How do you get one in criminal court? You have to have an underlying criminal charge. You can't just walk into court and say, I want an order of protection against my neighbor, he's a real pain in the butt. Can't do that. You can go to court, but there has to be an underlying charge. Could be harassment, could be disorderly conduct, could be menacing, you name it. Underlying charge would allow you to go before a judge or have the district attorney on your behalf make the pitch, say, it's not the client of the DA, but it's the complaining witness, needs the order of protection. The judge will make a decision. Could be a temporary one that could become permanent. Permanent could be 2 years, could be 3 years if it's a misdemeanor, 5 years felony, could be 10 years if it's a sex offense. So they can last a long time. How do you get one in family court? Now, this one gets a lot of people. You have to have what they call an Article 8 violation. Article 8 could include assault, harassment, disorderly conduct, menacing, stalking. Not all charges. Rape is not an Article 8. Now people go, wait a minute, you can't get an order of protection for rape? Of course you can. Not in family court. You'd have to go to criminal court. I remember there was a referee named Burke, and he had a very deep voice, and he would always stand. He didn't sit down. And when someone came in, he'd say, where is the Article 8? What he meant by that is if you don't have an Article 8, you're not getting an order of protection, or if some other judge or referee gave it, you're not going to keep the order of protection. I'm going to give you an interesting story I had, a case I had some years ago. My client did certain things that would satisfy the criminal statute. But in family court, again, it's got to be an Article 8. So a judge gave an order of protection, and now we were before Burke. And I had two attorneys on the other side saying, work out a deal, you can't win this. And I said, I'm going to win this because there's no Article 8. Yes, what she did could fall under a number of criminal statutes, but we're not in criminal court, we're in family court. We had a trial, lasted a few days, and at the end of the trial, referee Burke, who is a referee, not a judge, but he has the power, because the parties agree he can handle the case. He has the power of a judge. Dismissed the case, saying there was no Article 8. Simple. If it's not an Article 8, you can't get an order of protection in family court. Even if they give it, sometimes a judge might say, it's a close call, I'll give it to you, come back, the other person will get their day in court. Case was dismissed. Could that person have been prosecuted criminally? Of course, but that's not where the case was. All right. Give you another example. This was a case that could have landed my client in jail with a potential felony. There was an order of protection before I got on the case that said he could not go to his wife's home located at, and it gave an address. Right. If it had just said that Mr. Jones, whose name is not Mr. Jones, but can't go to his wife's house, and she doesn't live there anymore, that's a defense. So if she moves and he goes to that other location, she's not there, he's okay. What happened was she moved to another location, out of state. At some point he said, she moved, I'm going back into the house. Again, he wasn't my client yet. I would have advised him, don't do it that way. But he went back in the house. Then one day, she decides to come back home. Pulls in the driveway, he sees it, sees her there. Better get out of here, grabs a few things, and he leaves. She calls the police. So instead of saying no harm, no foul, he's gone, she calls the police and he's arrested. They make an offer, and my client said, look, she's had me arrested before, I have to take a stand. We went to trial. Now, he would have had a criminal record and potentially could have gone to jail. Jury found my client not guilty. Now, was it a technical violation of the order? Yes, it was. A technical violation. Because it says stay away from the home located at. She had moved out, but that address was mentioned in the paperwork. The jury decided for a not guilty verdict. My client was cleared in all charges. So that's an example where sometimes you have to take a stand. Because if he takes the plea, she knows that she can get him in trouble for a number of things. Then there's the order still, and he was afraid she would use that order as a sword and not a shield. So she could make up something or just not be happy with him, call the police, he gets arrested again, and it escalates. I always say this, that an order of protection is only as good as the person it is served on. What do I mean by that? If you serve an order of protection on someone that is hell-bent on killing the other party, it's a piece of paper and it's not going to amount to a hill of beans. Does that mean it shouldn't be issued? No. Judges have to follow the law. But the person who gets the order of protection should be careful. I've had cases where people were killed with orders of protection that I represented. If a person wants to kill someone, a piece of paper is not going to stop them. And I'm going to say it again. That doesn't mean you don't give the order of protection. I find that an order of protection is best served on someone that might be a big pain in the neck. He's not necessarily a nice guy, but he doesn't want to get arrested. He wants to get up in the morning, go to work, maybe see his kids. He doesn't want the hassle of being arrested. That's the kind of guy that's probably not going to violate the order of protection. I had a client whose husband killed her and her mother, stabbed them to death, with the 8 and 10-year-old boys in the house. Didn't hurt them, but he killed their mother and their grandmother. It's a piece of paper, the order of protection. It's almost like you can get like a panic button, and the police can provide it, and you wear it, and if someone's breaking into your house, let's say your spouse comes by, you hit the button. It's not foolproof. Yeah, the police will know potentially where to find your body, but it might not stop that killer from killing you. Because unless the police are right at your front door, even if they're down the block, if this guy is hell-bent on killing his wife, his girlfriend, whatever, it could happen. So if you get an order of protection, you still keep your eyes open. Now, what are the exceptions to these orders of protection? Let's just say a father has an order of protection served on him, and it says stay away from your wife and your 2 kids. Can he see his 2 kids? No. What does he do about it? We would have to file a petition. It's called a subsequent order. So if I file a petition to get my client parenting time, as long as it's a subsequent order happening after the order of protection, it can allow my client to have parenting time. So the order can say, and I had one just like this the other day, it could say, this is order of protection. However, on Saturdays and Tuesdays from 4 to 8, Dad is allowed to pick up the kids at the 4th precinct. We don't always like to do precincts, but sometimes you have to. And drops the kid off at the 4th precinct at 8 o'clock, 10 o'clock, whatever. That order will allow him to do so. So if the police show up and say, wait a minute, she's got an order of protection. Oh, wait, it's Saturday and it's 4 o'clock and you're picking the kid up, you're okay. I had a client call me and said the mother of his child didn't want to do the schedule that they had, the subsequent order, but wanted to do it the next day as a makeup. And I said, you can't do that. Because think about it, if the order says Sunday 4 to 8, he shows up on Monday, doesn't matter what time, the police are called, let's say. They show up and they say, where's your subsequent order? Here it is. Wait a minute, doesn't say Monday, we have to take you into custody. That's a problem. So as the attorney, I had to tell him, you can't do that. Because if you do that, you're opening yourself up for, for a whole world of hurt if she picks up that phone. So a subsequent order can modify it. I had a case the other day where in criminal court, remember I said, you go to criminal court, there's an underlying charge, and you ask for an order of protection. We opposed it, and the judge did not give the woman an order of protection. I had my reasons, I stayed on the record, and the judge accepted those reasons as valid, and they were. So the underlying charge didn't go away, and maybe she'll get an order of protection down the road. But at that moment, the judge says, I am not giving you an order of protection. What is the length of an order of protection? Generally 1 to 2 years in family court. It can be 1, it could be 2. If you go to hearing and lose, it's usually 2. You can negotiate 1. In criminal court, if it's a violation, it's 1 year. If you're found guilty of a misdemeanor, let's say you assaulted your wife, and it's a misdemeanor, 3-year order of protection. Felony, generally 5-year. If it's sex abuse or something like that, and there's a sex offender registry involved, it can be 10 years. Now, my book, Chapter 14, talks about orders of protection. If you want more information, it's a good resource. In the last few minutes we have, I want to talk about how new technologies impact on family court issues. What do I mean by that? Driverless cars now are coming out, almost like the Jetsons. We have no driver of the vehicle, but the car is on the road and it can take passengers anywhere. And we're going to have cars, we're going to have planes that do that at some point. Just like we have drones now, we're going to have that ability. And we try to keep up in the family law area with new technologies. So now, let's say there's an order of protection and the mom and the dad can't see each other, but they have to exchange the children. What about a driverless car? What if that car drives over to mom's house, picks up the 2 kids, takes them to dad? Is it viable? Yep. Maybe now I'd be a little nervous because you hear about the car accidents that they have. But at some point, it's going to be safer than somebody behind the wheel of a car. So, will they be able to do that? Who makes that decision? Now, it might be the custodial parent saying, I don't trust that vehicle. The father might say, that's my only way to see my kids. A court could rule on that. All right? Now, if in our lifetimes, you're going to have driverless airplanes, what if the father lives in California and he can't afford to keep going back and forth? Maybe they can employ, in the future, a driverless plane, where the children are put on that plane and it's flown to California. Almost like a drone, except there'll be people in it. Another one is robots, providing childcare. You're going to have that at some point. I'm a little worried. I'm thinking of the Terminator. You watch that movie where they're going to take over the world. I'm worried about that. It could happen. But robots can do amazing things, and eventually they can provide childcare. Okay? Tracking chips. Some parents might want it in their child, some might not. Now, my engineer was just telling me credits. What do you mean by that?
We got to run the credits, so,
Okay. So we only have about 2 minutes left. So And the last thing is drone technology. I was going to tell a corny joke about drones could take over for storks delivering children, but I'm not going to say that joke. I thank you for watching the show. We're going to be on Saturday at 10 a.m. on channel 115. And for your insomniacs, I'm going to be on Thursdays at 1 in the morning. Thank you for watching the show. You can also catch me Friday nights at 8 o'clock. It's a live show, a little bit different, a little more politics involved. Thank you for watching. You have a good night.